of Tennessee is now in session.
Good morning, Council. Thank you for joining us by video today. We'll conduct the case just like we do if we were all in court, except we'll just be looking at each other's faces like this. I don't think you'll see much difference otherwise. Mr. Hivner, would you call the first case?
Beverly Gardner versus St. Thomas Midtown Hospital.
Good morning,
Okay.
May we proceed?
You may.
May it please the court, I'm Timothy Shee of the Davidson County Bar, representing Beverly Gardner and the appellant in this matter. Two quick things. Is my audio okay? Can everyone hear me all right?
Yes.
Yeah.
I'm reserving 5 minutes for rebuttal. And before we get started, because of some health problems, I had to ask Mr. Sheehan to allow me some extra time to file my briefs, which he graciously granted, and I want to thank him for that. May it please the court, this is a Rule 3 appeal of right from the Fifth Circuit Court of Davidson County, the Honorable Judge Joseph Binkley presiding. The underlying litigation at the trial court was a cause of action under the Tennessee Healthcare Liability Act brought against St. Thomas Midtown Hospital. The order appealed from was an order granting St. Thomas's motion for summary judgment. Now, I'm going to step back and take a macro view of this argument. I'm not going to go through all the details of the case or all the legal arguments made, because I think that'll just confuse the matter. I've done that in the brief. But what I would like to do is step back. The whole gravamen of this case is, what are the reporting duties of St. Thomas or any other healthcare liability defendant under the statute 2926-121, subsection A5. That was added sometime in 2013, and it requires, in our opinion, that once a defendant receives pre-suit notice, that within 30 days they have to inform the plaintiff of any other potential defendants in the matter. And the case, unfortunately, that directly on all fours defining this, is the case of Calissa Buildwell versus Straight, which we've cited to in our brief. That was decided in the fall of last year, and in February of this year, Tennessee Supreme Court granted certiorari, or granted a TREP 11 appeal, and it's up at the Supreme Court as we speak. As of last night, the Tennessee Supreme Court has not yet rendered its opinion in that case. So we're kind of laboring under a handicap here. We don't really know how that's going to be construed.
Mr. Ishii, if the Supreme Court ends up reversing our interpretation of the statute in Bidwell, does that resolve this appeal against you?
Reverse how? As far as the reporting?
Yeah, it determines that there really is, that A5, that basically Mr. Sheegan's argument is correct on the proper interpretation of that. It's not, doesn't do a mandatory of all potential responsible parties, but rather instead was intended to cover situations where the wrong party was sued and that party is then supposed to say, no, this is the correct entity. If the Supreme Court agrees with that type of interpretation as expressed in St. Thomas's brief, does that mean that we should affirm in this case the dismissal? And if not, why not?
Well, I'm going to be strong in my argument. I would say no, and here's why. Then I would ask the court how a potential plaintiff would find out who would be the correct defendants in this matter, because normally you file suit against the hospital. Now there's all these intricacies of anesthesiologists and emergency room physicians being agents or independent contractors. But stepping back, like I said, how would a potential plaintiff know who's involved? Because Mr. Sheegan's a very good attorney. He's not going to let a
Yeah, but
potential.
in a case like this, isn't it somewhat unique because the alleged harm was allegedly caused by anesthesiologists. And as St. Thomas points out, law prohibits the hospital from hiring the anesthesiologist. So this is somewhat different. You sort of go in, you go in with the knowledge that, they're not going to be employees in this case. Doesn't that make this somewhat different and more difficult from your standpoint?
Well, I'm arguing from the point of the layman plaintiff. In my experience, the anesthesiologist comes in when you're going into surgery. You sign something, you're kind of bedazzled, and that precludes also that. Assumes that every plaintiff's going to immediately know that they were injured by some potential malpractice, and they're going to immediately go to counsel. So you have a full year to deal with. A lot of these people, the injury is not discovered until sometime later, or they're injured, but they don't think there was some malfeasance on their doctor's part. And so now we're into the running of the statute of limitations. And, Mr. Sheegan took the position that I believe that you have to file the pre-suit notice 60 days out from the anniversary of the injury. Well, that would push it back 10 to the 10-month mark, or in this case, she was injured on May 8th, 2016. It would push it back to March 9th. So it's shifting all the burden over on the potential plaintiff. And my question to the court is, how would a potential plaintiff or their counsel be able to discern who other potential defendants would be if there's not a reporting duty under the statute? Are there any more questions, Your Honors? If not, I'm going to. Yes, Judge. If not, I'm going to step back and let Mr. Sheegan take over.
Okay. Thank you, Mr. Ishii. Mr. Sheen.
May it please the court. I'm Pat Sheegan. My local bar is Montgomery, Alabama, and it is my privilege to be before your honors on behalf of the appellee, St. Thomas Midtown, in this case. With due respect to the appellant, Judge Binkley got it right when he granted summary judgment in this case. The plaintiff's claims against the anesthesia providers were barred by the statute of limitations at the time suit was filed against St. Thomas Midtown, asserting vicarious liability for the actions of the anesthesia providers who were not even employees of the hospital, but instead were independent contractors.
Well, let me ask you a question, sir.
Yes, Your Honor.
Okay, the action was barred at the time the suit was filed, but when the notice went out, was your client obligated to give notice of these agents?
Respectfully, no, Your Honor. It is our position for multiple reasons that Section 121A5 did not require the hospital in this situation to give notice. The Bidwell case, as we describe it in our brief, is quite distinguishable from this case. It involved a governmental tort liability action where the individual in question was an essential party to the case, the employer of the healthcare providers. Here, the agents are not an essential party, and so that case is distinguishable. The statute, if you look at the legislative history of that statute, that reporting requirement was part of several additions to the HCLA in which it appears that the purpose of the General Assembly was to make sure that proper individuals or entities, were corporate entities, or named, rather than the defendant have to identify every single potential healthcare provider who might be a proper party to a case. It appears to us that the General Assembly's intent when enacting this amendment was to ensure that passive investors not, one of the primary purposes was to ensure that passive investors not be named as the defendants in the case. And ultimately, we believe that in a case like this, it would be illogical for the defendant healthcare provider to be expected to have to identify every potential defendant in a case within 30 days of receiving pre-suit notice. Oftentimes, pre-suit notice is quite vague, and it's unclear what the claim is that the plaintiff is making. In this case, the pre-suit notice did provide indication that the plaintiff's claim was based on the care by the anesthesia providers. And so at the outset, the hospital got pre-suit notification that these anesthesia providers were the target of the claim. The plaintiff had the medical records. Ultimately, the plaintiff submitted a certificate of good faith, which indicated that they had an expert review the case and determine that there was a good faith basis to pursue this action based on those medical records. These anesthesia providers are clearly identified in those medical records. So, our position is, why would a hospital in that situation think that it needed to identify those anesthesia providers to the plaintiff? If you took this even further in this case, if the plaintiff's argument is correct, the defendant in this case would be called upon to identify Dr. Ulm, whose name is identified in the complaint, where the plaintiff is making reference to Dr. Ulm, but they gave no pre-suit notice to Dr. Ulm. And so the plaintiff could argue that the hospital should have given pre-suit notice to this surgeon who the plaintiff clearly was aware of, but they didn't give pre-suit notice to him. That would be very illogical, and we just don't believe that that's what Section 121A5 intended.
That language on A5 is rather broad, isn't it?
Yes, Your Honor.
Based upon any reasonable knowledge or information available. It doesn't say the information, if the information's already available to the plaintiff, you don't have to do it.
Right. I agree with Your Honor, but I believe that that's subject to interpretation, and it would force the defendant to if it were read as broadly as it could be read, it would force a defendant in a situation to go through a process within 30 days that the plaintiff isn't even required to do, before they consider pursuing a suit, or during the 60-day extension of the statute of limitations, or even during a 90-day extension grace period under the comparative fault statute.
Wouldn't the assumption be that the hospital would know best who else might be liable? Isn't that the assumption behind the statute?
Your Honor, I do not believe that's the assumption behind the statute. As stated before, I believe the legislative history gives indication that the real purpose behind that statute was to try to correct any mistakes that were made or otherwise ensure that proper corporate entities were named. I do not think that the purpose of the statute was intended to place a burden on defendants to identify every potential healthcare provider who could be culpable. Recall that oftentimes the pre-suit notification of the pre-suit notice is vague, and it doesn't clearly educate the defendant on precisely what the claim is.
Well, that may be true, but again, you look at the language of the statute, and it says provide written notice to the potential claimant of any other person, entity, or healthcare provider who may properly be named defendant. That's very broad, and we're supposed to interpret these statutes according to the language used, are we not?
Yes, Your Honor, I do, and I just think that it's broad language that is subject to interpretation, and it does not make sense in practical terms if a healthcare provider, if the language were interpreted to indicate that a healthcare provider was required in a case like this within 30 days of receiving pre-suit notice to be able to identify every potential party to a case. Particularly in this case,
if anybody could do it, it would be the hospital. And, well, go ahead. I'll stop.
Well, Mr. Sheegan, let me ask you the same question I put to Mr. Ishii. I mean, it seems to me that Bidwell may be significant here because if the Supreme Court does end up accepting this court's interpretation of the statute, then there might be an obligation on St. Thomas's part here to identify the fact that the anesthesiologists might be liable parties here. So would you agree with if the Supreme Court affirms Bidwell, then dismissal was probably an error here? And if not, why not?
Respectfully, no, Your Honor. I do not agree because even if Section 121A5 did require identification of these providers, the identification here would have occurred after the statute of limitations had expired as to the claims against the anesthesia providers. Recall that the pre-suit notice given to St. Thomas Midtown was not sent until April 25th, 2017, and the statute of limitations as to the claims against the anesthesia providers expired on May 8, 2017. Recall that there's no allegation in this case or evidence presented that regarding the discovery rule. So the plaintiff has argued in this case that they didn't know who the anesthesia providers were, but there's no evidence of that, and that was not alleged in the complaint.
So your position would be then we don't really have to wait on Bidwell, even the Supreme Court outcome on Bidwell, I should say, even under that broad interpretation, you're saying it's still too late, no matter what.
Absolutely, Your Honor. And again, if St. Thomas complied, if St. Thomas, despite all of the information that would have suggested to St. Thomas, the plaintiff already knew who the anesthesia providers were, if St. Thomas took that approach and decided to identify the anesthesia providers, that would have come after the statute of limitations had already run. And even further, Your Honor, if Bidwell says that the defendant here should have identified the anesthesia providers, unlike the plaintiff in Bidwell, the appellant here who made a tactical choice to pursue St. Thomas through a parent agency for this independent contractor and independent contractors only. The appellant here merely sat on her hands. Instead of doing what the plaintiff in Bidwell did, which was to file an amended complaint when she got the answer and try to add the anesthesia. The plaintiff in Bidwell filed an amended complaint to add the employer who was not identified by the defendants in Bidwell. And the Court of Appeals allowed that amendment under the grace period of the comparative fault statute. And the plaintiff here could have done the same thing when she received St. Thomas's answer, in which St. Thomas denied that the doctors who were alleged to be the agents of the hospital were agents. The plaintiff could have amended her complaint just like the plaintiff in Bidwell, and in the Romine decision cited in Bidwell, the court recognized that plaintiff in this situation where they're put on notice that there may be other potential defendants can amend the complaint within 90 days, adding those other providers, even if the statute of limitations has expired as to those new defendants. And so here, the plaintiff could have amended the complaint within 90 days of the answer filed by St. Thomas Midtown to name the anesthesia providers, but she didn't do that. This was a tactical decision to try to pursue a hospital for the actions of independent contractors. And so this is very different and very unfair. Recall too, that St. Thomas Midtown, when it gets pre-suit notification in a case like this, where the only claim is about the actions of the anesthesia providers who are not employed by the hospital, who are independent contractors, Tennessee law does not allow St. Thomas Midtown to have any contact with those anesthesia providers because they are independent contractors. St. Thomas has no control or access to those providers. We couldn't interview them. That defeats the whole purpose of the pre-suit notification process, where the plaintiff made the tactical decision to try to hold the hospital responsible for the actions of these independent contractors. And based on all of these things, Your Honors, we say that the trial court correctly held that there was no genuine issue of material fact, rejected all of these arguments by the plaintiff, and granted summary judgment. And we would respectfully urge Your Honors to affirm the decision of the trial court. Thank you.
Thank you very much. Mr. Ishii?
In response to Mr. Sheegan, I would ask the court to look at the case of Hall v. Crenshaw. I think we cited it in our brief, I'm not sure. It says that corporate entities have no knowledge in and of themselves. And so they have to be able to speak. In that case, revolved around whether it was a violation of a doctor-patient convention.
Confident.
In that, you know what I mean? I'm sorry, I'm tongue-tied. And they said no, because the corporation has to be able to investigate in there, and they have a contractual relation that they're in privity with these people. Going back to what Mr. Sheegan says, I'd ask the court, well, if St. Thomas doesn't, going back, Ms. Gardner did, in her original thing, she asserted it was cause of action against St. Thomas's employees, its agents, and its agents. And I think that's why they didn't modify that afterwards. They had alleged against employees and agents, unlike these other cases where they had to go back and then try to amend the complaint to include unknown agents in their complaint, in the ambit of their complaint. There was no, as far as I know, speaking with Mr. Blanton, there's no conscious decision not to sue other people. They just sued who they knew, and who was reasonable they could have known was liable under the Healthcare Liability Act. So we'd ask the court to respectfully, I think we'll have to wait till after Bidwell and then consider that. And should the Tennessee Supreme Court find, as we believe it should be, that there's an affirmative duty on the part of the hospital to supply other possible defendants under the statute, to reverse the trial court's decision, grant summary judgment, and reverse them and send the matter back down for hearing on the merits. Thank you.
Thank you. Thank you both.
Thank you, Your Honors.
We appreciate your arguments today.
Thank you.
Clark?
This honorable court is now in recess until 11 a.m.